Welcome to Ceasefire Educates, a video series by Ceasefire Oregon. My name is Penelope. I'm a high school student from Portland interested in helping others understand certain gun policies and how they effectively save lives and reduce gun violence in the long term. Most gun-related videos on the internet are partisan and biased, but this series is strictly evidence-based. Today I'm going to talk about extreme risk laws. ERLs go by different names like Extreme Risk Protection Order, Gun Violence Restraining Order, Lethal Violence Protection Order, Risk Protection Order, Firearms Restraining Order, and Proceedings for the Seizure and Retention of Firearms. But they're all essentially the same thing. ERLs are legal tools that allow family members and law enforcement to keep at-risk but otherwise not gun-prohibited individuals from harming themselves or others by temporarily restricting their access to firearms. In most states, immediate family, household members, and law enforcement can petition a local civil court to temporarily remove firearms and prohibit the purchase of firearms from the at-risk individual. Some states deviate from that list. New York, for example, allows school administrators to petition. Hawaii includes medical professionals and coworkers. Oregon specifies family and household members, as well as law enforcement. It's important to know, based on where you live, who is eligible to petition. In most states, once a civil court has been petitioned, it will hold what is called an ex parte hearing with the petitioner. In addition to hearing the petitioner's testimony, the court will consider factors like the at-risk individual's patterns of violence, behavior with guns, substance abuse, and recent firearm acquisition. If it decides that the risk of harm is convincing, then the judge will issue an ex parte order. This order takes immediate action if the individual's risk is imminent and emergency, and law enforcement will 1. Temporarily prohibit the individual from purchasing guns, and 2. Temporarily remove guns from the individual's home. The at-risk individual whose firearms have been removed has the right to due process, so the court will hold a second time-sensitive hearing, which will conclude with a final order. Final orders usually don't last longer than 1 year, although they may be renewed or terminated early if the petitioner or at-risk individual present additional evidence. That's the process in a nutshell. As of today, 16 states and Washington, D.C. have implemented extreme risk laws, 10 of which have been implemented from 2018 to 2019. I'd like to cover 2 important aspects of ERLs that I'm sure many of you are curious about, so let's tackle them as questions. Number 1. Do extreme risk laws work? To answer this, let's use an example. In 1999, Connecticut became the first state to introduce extreme risk law in the form of Public Act 99212. Over the course of 14 years until 2013, researchers studied this law and its effects. Connecticut courts issued 762 orders, and in 99% of those cases, law enforcement removed at least 1 gun from the at-risk individual. On average, law enforcement removed 7 guns. In over half of the cases, law enforcement was concerned enough about the individual's mental state that it transported him or her to a hospital emergency department. This indicates 2 things, according to the researchers. 1, that gun removal intervention served as a signal or portal to help and support, and 2, that intervention served as a public health action to keep people safe. Ultimately, 21 at-risk individuals who were subjects of Connecticut's ERL died by suicide, 6 of them from firearms that had been returned to them after the court-issued orders had expired. Importantly, this proportion, 6 of 21, or 29%, was lower than estimates of firearm suicide among both Connecticut's adult and gun-owning populations. By extrapolating data, these researchers estimated that for every 10 to 11 orders issued, 1 life was saved. This is why many public health and gun safety advocates conclude that extreme risk laws provide a critical avenue to reducing gun violence. Number 2. Are ERLs constitutional? Yes. These laws have legal safeguards that ensure constitutionality. First, firearm restriction is temporary. Second, courts ensure due process by requiring warrant and notification of the at-risk individual. Third, these ERLs contain protections against false petitions. These 3 legal safeguards maintain that the civil rights of law-abiding gun owners will not be needlessly infringed. In Connecticut and Indiana, court rulings have upheld that states may restrict access to firearms from dangerous people if it is in the interest of public safety or an individual's welfare. Not only have ERLs passed judicial scrutiny, but they've also received bipartisan support. According to a Johns Hopkins survey, 90% of non-gun owners and 75% of gun owners support extreme risk measures. I should also mention that 7 of the past 16 ERLs have been passed by divided state governments. Extreme risk laws are a critical step towards reducing gun violence. By establishing methods of collaboration between citizens, law enforcement, and local courts, ERLs solidify means of keeping families and communities safe. Thank you for watching our first video. If you'd like to stay updated, please subscribe. We'll be back soon.